Welcome to Litigation Nation. I'm your host, Danessa Watkins, along with my co-host, Jack Sanker. And this is the show where we discuss recent legal news and exciting court decisions from across the country. Our shows come out every 2 weeks, and you can listen on Apple, Spotify, YouTube, or wherever you get your podcasts. So, Jack, what did you find for us to discuss this week?
Unfortunately, the tragic death of a 14-year-old boy who'd become obsessed with an AI chatbot raises questions about the ethical implications of this technology and draws a lawsuit from the grieving parents.
Oh, boy. Well, I will say that my story is a little lighter. I'm going to cover a recent ruling at the Georgia Supreme Court level throwing out the contempt conviction against attorney Brian Steele, who is representing Young Thug in a criminal RICO trial. All that and more, here's what you need to know. In what is now Georgia State Court's longest criminal trial in history, we're currently on month 11, the state has brought a 56-count RICO action against Jeffrey Williams, who is a successful rapper otherwise known by his stage name Young Thug, and a number of co-defendants, including 26 members of the record label Young Stoner Life, aka YSL. The indictment characterized YSL as a criminal street gang, alleging 182 instances of participation in gang activity and criminal conspiracies, citing both lyrics and social media posts of the defendants. Now, many of the defendants did take plea deals early on, so as of now, there are only 6 defendants on trial, including Young Thug. And the case arrived under the specter of a 60% rise in violent crime in Atlanta, and this is taking place in Fulton County, where the district attorney, Fannie Willis, has promised to fight, but has really drawn some criticism throughout the hip-hop community, where many have argued that this trial is just one of many instances of the criminal justice system unfairly tying rappers to violent crimes because of their art. So this case has been absolutely wild from the start, and I've been covering it or following it for a while, kind of just waiting until there was something that I thought I could bring to the show. And that happened just recently. So there was a ruling at the Georgia Supreme Court level which threw out the contempt conviction against Young Thug's attorney, Brian Steele. Now, all of this started, and just for a minute, it's not common for a criminal defense attorney to be held in contempt, right, let alone be, hauled off in what do you call them?
Handcuffs?
Handcuffs,
yeah.
Thank you. Handcuffs.
Civil litigation attorneys here, yeah.
Yeah, sorry, we're not used to that. That's not the norm. So for this to go up to the Supreme Court level, was obviously appropriate because this is a rare situation. But let's go back. So this all started in June, and it surrounded the testimony of the prosecutor's star witness, Kenneth Copeland, who goes by Lil Woody. So Lil Woody was offered immunity for his testimony, but then he refused to take the stand when it was his time. So the judge at the time, Glanville, held Lil Woody in contempt. I'm going to just call him Copeland because that's instead of saying Little. So held Copeland in contempt and called a meeting in chambers between him, so the judge, Copeland's attorney, and the prosecutors. Now, this is what we call an ex parte communication, which essentially is a communication between one party in a lawsuit and the judge without the other party present. As a general rule, and this is both in criminal and civil actions, ex parte communications with a judge are strictly prohibited.
Especially in criminal, though. It's equally bad in any other case, but, this is, someone's right to not be in prison. We're talking about.
Exactly. It's, due process rights. You have to maintain the neutrality of the judge and also just have an opportunity for both sides to present their positions. There are, certain rare circumstances where ex parte communications are allowed, but certainly this is not one of them. So here, one of the mornings of trial, the judge, the prosecutor, and then this key witness met in secret. The defense team was never told about the meeting, given a heads up or anything. So they were just showed up for trial. We're sitting there for hours waiting. And then when court finally started, somehow the defense attorney, Attorney Steele, he found out about the meeting. Now, he addressed this issue to the judge in open court. He objected to the ex parte meeting and filed an oral motion and probably later a paper motion for Judge Glanville to recuse himself. Mm-hmm. Now, the footage of the argument that ensued between the judge and Attorney Steele is unbelievable. I'm going to try to play the clip here. I'm hoping it'll come through. But it's just to kind of tee it up. So Attorney Steele has just stood up to make a statement, and he revealed to the courtroom, the jury was out at the time, but everyone else was in the courtroom, that it had come to his attention that the judge had this improper ex parte meeting. And you'll hear the judge's immediate response was to question how the attorney learned about it.
Yeah.
Attorney Steele doesn't answer the question, but instead starts to read case law confirming that all defendants have a right to be present for communications with the court. I mean, he didn't even need to cite a case for that. That's just common knowledge. So that's what's happening right before this part of the clip that I'm going to play.
Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said.
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to get anybody else.
I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have I have problems right now.
Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
a witness who was sworn in Friday. The court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it proprietary?
Or information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why?
Sir, I'm going to hold you in contempt if you don't tell me who tell me who this information was coming from.
I don't want to be held in contempt.
Well,
I'm not answering that question. That's attorney-client privilege information. I am not answering
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I tell you
what, I'm going to give you 5 minutes. If you don't tell me if you don't tell me who it is, I'm going to put you. I'm going to put you in contempt because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
I mean, wild.
Yeah. I like when he amends his statement. He addresses the court as this honorable court and says, "Excuse me, actually, this court."
Yeah,
It's
no,
just-
like what a G. And for the judge to call it proprietary information, I mean, clearly the judge was rattled and immediately went into like defensive mode.
100%.
You know, but for him to say, you know, we have a right to these ex parte communications with a party. And I don't know if this was clear from the audio, but so this star witness for the prosecution said he's going to take the fifth, said, you know, he'll do his time, essentially ripping up the immunity deal. And after this meeting, decided to take the stand. So that, I mean, something happened in chambers.
Well, or the judge could have denied, and which was the question. The question was, is this true? Did this indeed happen?
Yeah.
And the judge said, well, where did you find that out from?
Exactly.
Instead of saying, you know, if it didn't happen, right?
Yeah.
The court could have said, you know, counsel, you're mistaken. That didn't happen. You must be confused. At which point they probably would resolve the issue. Instead, the judge is like, well, wait a second. You're not supposed to know about that. Is what it seems like.
Right. Exactly. He wants to find out the leaks in his, you know, system.
I think it's later in this because I've seen this clip too. It may not have been in the part that you played, but the attorney requests that he serve his contempt time with his client so he could prepare for trial.
Yeah.
Which is like a pretty slick move.
Oh my God. I mean, this was like, we obviously don't do criminal defense work, but this to me is like, you know, you hold this guy on a pedestal. Like if you're a criminal defendant, 100%. You want an attorney like this.
His phone has never stopped ringing after this clip went out. Like and this, I mean, Young Thug is about as high profile a client as you can get, but like, this, I remember when this happened, not all that long ago, but maybe a couple months ago, and I remember like the amount of like just people, social media, and even friends and family just being like, "That's who I would want as my attorney,
100%.
Who's willing to go to jail for me,
Right.
willing to spend a couple of nights in prison, you know, to protect my rights at trial," which is, I mean, courageous.
Yeah. Well, because he knew it was wrong.
It was, but a lot of people would say, "Well, I'm not going to prison for my clients."
Exactly.
And,
yeah. No. He got a 20-day jail sentence, which he was supposed to serve on the weekends so that he could, you know, continue trial. But yeah, when he got escorted out of the courtroom in handcuffs. And yeah, ultimately said, sure, I'll serve my time, but it better be in the same jail as my client so we can continue preparing for trial.
Yeah. And then I think there is a moment in the video where like he like says that or whatever, and his client like fist bumps him across the table, and it's like a pretty like epic moment, you know? And, like this guy's going to advertise on this for the rest of his career. Like,
Yeah.
Yeah.
And what a bad look, obviously, too, for the Fulton County judiciary. I mean,
Yeah, and it may not have even, 'cause I don't know the fault, maybe I don't want to take away from the rest of your story, but I don't know if it even was necessarily malicious or nefarious, like that communication. It could have been, I don't know, but
Yeah, we don't know.
The fact is, that's the reason why ex parte communications are prohibited.
right. And I'm sure you've come across this too. There have been times where sometimes like an email is sent to the judge and you leave somebody off or whatever. And the judge takes it upon themselves to say, just so you know, this communication was sent. You know, the judge is supposed to keep, like, because sometimes things happen.
Yeah.
But the judge is supposed to have that, you know, that duty to then inform the other side that this occurred.
Yeah, I mean, if you
And-
walk into the courthouse and you get there, you know, 10 minutes early before your hearing, and the judge is sitting behind the bench, you might just start chatting. And then the moment the other lawyer walks in the room, at least for me, you always explain, you know, counsel, we were just chatting about like the Bears game.
Sure,
or,
sure.
you know, we were talking about the traffic this morning. We weren't talking about the case. Or if the case did come up, you would immediately go, you know, this wasn't an important issue, but hey, we saw that there's a deadline next week. I was going to suggest once you got here that we move this deadline. You know, something
Right.
like benign or not important. A criminal case like this, you wouldn't do that.
No, I mean this trial started late November of 2023, so they're now 7 months into trial, and the key witness for the prosecutor is the one that was at issue here. So yeah, you can't be having communications with that witness without the other side present.
Or if you did, it is incumbent on the court to be like, hey, thanks for telling me that information or whatever. I have to now share it with the other side.
Right.
It cannot be that the other side finds out independently,
Right.
and then you deny it.
And then you take offense to
Yeah, and then you put the guy in jail for it.
right.
Yeah,
I mean,
like the judge ought to be
Sanctioned.
well, the judge ought to be apologizing
Right.
to counsel. Like when this
Right.
comes up, you should be like, you know what, that is what happened. At the moment, the guy just walked into my office and started talking, right? I can't stop someone from doing that. It was ex parte. Let me tell you everything that went down. We're going to do a hearing on this on the record outside the presence of the jury.
Right.
I will sign an affidavit as to like what was said. You do whatever you can to make it right.
Right, exactly.
Do not throw the guy in jail.
I know. Yeah. So obviously the attorney appealed the contempt, and he and other defense counsel did file the motion to have the judge recuse himself. That process took about 2 weeks, and then they did take Judge Glanville off the case. At the Supreme Court level of Georgia, this ruling that just came down, so Attorney Steele had filed a 46-page long appeal excuse me, to the contempt conviction, and the justices, they really didn't even address much of his arguments. They just said, look, Judge Glanville clearly should have recused himself from handling the contempt charge. Like, you cannot have that same judge issuing, this
Right.
contempt. So for that basis alone, they threw it out. So the judge was removed from the case. Now, to get into some of the craziness of this case, and this is just tip of the iceberg stuff. After that, Judge Shakura Ingram was appointed to the case, but then she had to quickly recuse herself because one of her former deputies had a romantic involvement with one of the co-defendants. So she's off the case. Then there was, at some point, there was a 6-week hiatus, and trial resumed again in August. Now the new presiding judge is Paige Reese Whitaker, who I have to say I like a lot. I've been listening to some of her rulings, and she's really taken control of this courtroom and just enforced, the level of decorum and professionalism that we really should expect from our profession. She's also come down really hard on the prosecutorial team, which, in some ways is a bad look for the DA's office, but really, the judge is holding them to their duties. And I think that that's, important for a lot of reasons, but two that just come to mind is that we've already had an instance of an ex parte communication with a prior judge. And Judge Whitaker then did what that former judge should have done. In a recent situation, there was another ex parte email from the DA's office that failed to include the defense counsel. She brought it up in open court and flat out said, like, you all know better. Like, stop this.
Especially now, especially after, everything that's already happened.
Mm-hmm. Yep. No, she called them right out on it. And also, this case is going to hit the year mark in November. It takes a lot of money, taxpayer money, to prosecute a case like this.
Yes.
And with everything that's been going on, there are just so many potential arguments for a mistrial, certainly for an appeal.
Yeah.
And
that's the other thing is, like, I don't know anything about the merits of the prosecution, but, like, good luck with this conviction.
Seriously.
Withstanding
the
like roughly 50 appealable issues that we just mentioned.
Right. And so Judge Whitaker is really just, I think, trying to do everything she can to right the ship and not make, the last year for, worthless. So it's interesting. So what she did when she took over the case, she essentially said that she instructed the jury, they have to ignore all the prior testimony of Lil Woody Copeland that came after that improper ex parte meeting in judges' chambers. So he had to pretty much restart his testimony. Now, in another crazy twist, in mid-August, Copeland's attorney was unexpectedly suspended from practicing law.
Amazing.
And this was in the middle of his testimony. This stemmed from unrelated issues that involved a 2017 child support case. But this left the testifying witness without legal representation. So that, had the court scurrying to try and make sure he had representation so that they could continue. The prosecutor had played hours of tapes of Copeland's 2015 confessions to the police, which implicate Young Thug and other YSL members in a murder. However, when Copeland was questioned about his prior statements, he backtracked, said, no, I was just trying to protect my family, and I, had to falsely implicate Young Thug in various crimes. So he's now, now that he's been forced to testify, he's going back on everything, essentially. There were also multiple things that, even though he testified to them a few months ago, he's now saying, I can't recall. Now, if
and this is the prosecution's star witness.
Star witness, yes. Now, if that wasn't enough, another dramatic twist is soon after giving all of this testimony of I can't recall, Lil Woody released a song titled I Don't Recall.
Amazing.
Which directly references his courtroom testimony. And just, the song lyrics just echo his repeated use of the phrase I don't recall during cross-examination, where he just,
listen, there's no such thing as bad press, right?
So, I mean, we have a jury that's going to have to weigh this witness's credibility, determine whether, he's just capitalizing on his testimony or if he's blurring these lines of his role as a witness versus a public figure. But obviously, this is just a ridiculous blow for the prosecution team.
Yeah. I mean, a lot of this is self-imposed. I mean, it's good lawyering on the part of the defense, it seems like. But a lot of these are completely self-inflicted wounds that you just, don't need to do. And, as a prosecutor, if you find out that a witness has walked into the judge's office and wants to start, and you find out, you're like, oh my God, this is going to blow up my case on appeal.
Right.
I am, I'm prosecuting this person. I'm going to run to the defense and tell them that this happened. I would immediately do my best as the prosecutor to remedy this, even if the court doesn't, which the court should, because I've created this massive appellate issue.
Right.
So yeah, it's
now this. And Judge Whitaker has more than once shown her clear frustration with the prosecutors. She went so far in one of the days of trial, she essentially said, this case has gone on for so many months because you are flying by the seat of your pants. It's clear you had, no direction in bringing this. And really, she ended up having to, stop herself and take a recess because you could tell she was, holding back so much frustration.
right.
Because I think she sees at the end of the day, this is potentially such a waste of time and money. And, it could have been handled so differently.
Or, I mean, the other concern is that this, and again, I don't know anything about the merits of the case, but a legitimate concern is that the accused are guilty.
Right, exactly. And you're blowing it. Yeah.
And you're blowing your opportunity to put someone behind bars who should be behind bars. And again, I'm not saying that's the case. I don't know the facts.
But yeah, that's the other side of it.
But
exactly.
Yeah. So as a member of the public, you should be frustrated for all those reasons. Either it's basically I don't want to say frivolous prosecution, but one that is just not being done properly. And that's a waste of time and money that you should be upset about. And this is the state's one opportunity to address these alleged criminal acts, and they're blowing it. And so both of those things should be infuriating. Yeah.
Yeah, absolutely. And then, just because I have to put my free speech twist on this, and just kind of digging into this case a little bit more, I have to say I just take issue with this idea of...
The song lyrics.
Yeah, using an artist's work as evidence against them in a criminal trial. I mean, I know New York, I'm sure there are other states that have come out with statutes against this. But, I mean, music artists take on personas. Especially the rap culture. They portray themselves as tough, streetwise, sure, walking the fine line, if not jumping over the line of criminal activity. But, do musicians write about real life events? Sure. But do they also write about things that never actually happened or skew the truth and, tell a story in a way that's going to be, attractive to the public? Of course they do. And when I was thinking about this, I was like, all right, let's take it out of, rap culture for a minute. What's another genre? Country.
Sure.
All right. Carrie Underwood. I dug my key into the side of his pretty little souped-up four-wheel drive.
She might have done that.
Carved my name into his leather seats. Like, she's literally singing about property damage.
Yeah.
So if an
probably like stalking and harassing.
Yeah. So if an ex-boyfriend came forward and said, I dated her, and then suddenly, I don't even know, my prized baseball card collection got ripped up. Like, are they going to play that song in court and be like, yeah, this is her MO? Like, but I'm just like to take it to that level. Like, we think that's silly, but I'm sure these rappers feel the same way. Like, are you seriously holding me, accountable for things I put out as an artist?
Yeah, I don't know. Because I also think that, it would depend on the specific statements in the song as they relate to the specific allegations of the crime. Right?
No doubt.
If there's like a part of the song that's like, hi, it's Young Thug and I committed the following crimes on these dates with these people, then I do think that's fair game.
Well, I think there has to be a threshold, right?
Right.
Like, there has to be a clear, evidentiary hearing of showing, and I don't know if that did or didn't happen in this case, so, I can't say one way or another, but...
what's the objection? Is it a relevance objection then? Because it's not hearsay, right? Because it's an admission. So it would be like a 403 type relevance. This is more...
Yeah, more damaging.
Or is it unduly prejudicial compared to probative?
Right.
Yeah,
exactly.
but that's like a normal thing that judges have to deal with in every case, I guess that would be the ruling I'd be interested in. I should have read it, frankly.
Well, and I don't know, I don't know if this came up in pretrial in this case or not. I would assume, this attorney seems to know what he's doing, so I would think it came up. But yeah, I just, I don't know. It raises red flags for me, for sure.
Right. Well, yeah, it's one of those chilling things. It could theoretically have a chilling effect on speech.
Right.
And there's reliability questions as well about whether you could rely on that type of thing. Yeah, people make up things in music all the time, for sure. That said, there probably is a time and a place for it, for the prosecutors to use those statements. If, like I said, if it's hyper specific, right?
If it's hyper specific, yeah. But if you're just going to play a bunch of songs and say, this is, and make that your character evidence, of a person, it's that obviously I take issue with. And yeah, what are we going to do? Someday we're going to end up with, bland songs with happy-go-lucky lyrics.
Yeah.
That's all because people are going to be scared to, talk about anything real.
Right.
I don't know. That's probably taking it too far. I'm sure people will always put out things. But who knows?
Yeah, no, I always think about the Reasonable Doubt album. Jay-Z did a whole album about how he got off from his criminal charges, and it's I imagine the prosecutor hearing that being like, damn it.
Yeah. Well, have you seen now too all the things that are coming out about Diddy and how all of these artists have for decades been telling us in their lyrics
coded,
Eminem has put out a bunch of songs where he's calling Diddy out, and only now are we oh shoot, he was warning us.
That's another thing.
That's a totally different subject. But
that's probably, we'll get an episode of that down the road, because I don't think that
we need to get that case needs to get moving a little further before we cover it. But all right, since this is an ever-evolving case that continues to be on trial, it's a wild one.
It's a fantastic case to kind of watch as an outside observer, setting aside the merits of the accusations and all that stuff. Good lawyering, interesting stories. It's been everywhere, social media.
Yeah, yep. So we'll keep you updated.
All right, our next story is a bit of it is a downer. I shouldn't say it's a bit of a downer. It is a depressing story, but I think it's important to cover. It very much is in line with the story that was we covered on our last episode related to the TikTok lawsuits. And on that episode and the lawsuits we talked about there, basically boiled down to allegations that TikTok and social media more broadly, it poses a mental health threat to young people. It's addictive and it can exacerbate mental health conditions, whatever. This is an extreme version of that, and this is as it relates to a specific AI chatbot app by the name of Character.ai. So we'll start with what is the app? Character.ai, and kind of more broadly, there's a lot of AI companionship / friend apps that are on the market. Some of them are like just overtly pornographic, so you can like have like sexual exchanges with these chatbots or whatever. And other of them are just like goofy, playful. Like you could just chit chat like a friend. I mean, I remember as far back as, yeah, my producer's nodding along. I remember as far back as like the early 2000s. Remember AIM? Do you remember remember Smarter Child?
Yes. Yeah.
Which
wow,
was
blast from the past.
Yeah, and so you could, and it was like something you did like with your friends at a sleepover. You would just be like, "Hey, Sporter Child, like, why do you stink?"
Yeah.
It's like stupid things, like, and it was like funny to get a response back from a robot.
Right.
So some of them are like that, and then some of them are adult, like explicitly adult. Some of them, I mean, a lot of them are like the ones that some of the listeners are maybe using, like ChatGPT, where you can use it for more practical things.
So but some of them are legitimately like you're just chatting, and you're chatting with AI.
Yeah. They don't. Okay. The app does not try overtly to deceive the user. Like they're not saying you aren't talking to a real person.
Yeah.
Right? They're open about that, and even in the chats that you have on Character.ai, like in the text box, it says like as a reminder, something along the line of like, reminder you were chatting with an AI.
Got it.
Something like that. So the idea is like, hopefully you don't forget that.
Yeah.
Character.ai, their users get to kind of create their own custom chatbot based on like whatever preferences they want. You can talk to like historical figures. I'm going to be relying today a lot on the recent New York Times article, which was from October 23rd by Kevin Roos. And in that article, he describes Character.ai as follows, quote, "Users can select from a vast array of user-created chatbots that mimic celebrities like Elon Musk, historical figures like William Shakespeare, or unlicensed versions of fictional characters," unquote. In this case, would be Daenerys Targaryen, which is the character from Game of Thrones. Mm-hmm. That is who the individual, the 14-year-old boy that we're going to be talking about here in a moment, decided to set up this like chatting relationship with. As an aside, yes, all of these, anytime they're using these like fictional characters that are like licensed IP, like they are not paying licensing fees. So like there's like, that's a whole nother conversation, but this, I think is also doing blatant intellectual property infringement, but separate discussion. Anyways.
Allegedly, as your defamation attorney.
My opinion.
Okay.
Yeah.
That's not going to save you, but
yeah.
Go ahead.
Anyways. So there's a lot of different ways you can use them, and they're marketed differently. They're marketed towards all types of things. This app in particular has some concerning traits, I would say, that make it stick out, at least in light of what actually happened here. Going back to the New York Times piece, quote, "Some of Character.ai's most popular chatbots had names like Aggressive Teacher and High School Simulator, and many seem to be tailor-made for teenage wish fulfillment. The description of one popular character, which has received 176 million messages from users, read, your boy best friend who has a secret crush on you," unquote.
So these are like preloaded. You're not making up these.
I'm not sure. I think
maybe it's a little bit of both.
Yeah, I think maybe you can make your own, and then others can use it.
Oh, okay.
I'm not exactly sure, but some of the most popular ones on this platform are like clearly targeted at people under the age of 18.
Yeah. Okay.
A spokesperson for the company said, quote, "Gen Z and younger millennials make up a significant portion of our community, and that younger users enjoy the character experience both for meaningful and educational conversations as well as for entertainment. The average user spend more than an hour a day on the platform," unquote. So theoretically, they are at least acknowledging that a lot of their users are young children, which should imply a certain amount of like safety and things like that. Mm-hmm. So the individual that we're going to be talking about here, and I'm going to say this, and I'm going to try not to dwell on it, but for those of you that are listening that are sensitive to this type of thing, this story does involve the death of a 14-year-old boy, and does involve him taking his own life as a result. So there's really no way to say that. that expresses enough, sadness about that fact, but that is what the story is. So skip to the end if you want to get past the sad part. So the individual is a 14-year-old boy from Orlando, Florida, whose name I'm not going to mention. He apparently had spent months talking to chatbots on Character.ai. He specifically, as I mentioned before, was using one that was created to mimic Daenerys Targaryen from Game of Thrones. And he knew, or he would have known, that this was an AI model. Like there's a lawsuit that came out of this. There's no allegations that he was confused, that he was talking to a real person. So nonetheless, he developed, frankly, according to his mother, who's interviewed for this piece and who eventually filed a lawsuit, which we'll talk about, and records that were reviewed by the New York Times, clearly developed an emotional attachment. He texted the bot constantly, talking to it, dozens of times a day, engaging in long, role-playing dialogues where he pretended to be a Game of Thrones character, which is, I don't know, that is not all that weird for a little boy, to pretend. Playful. Yeah. But some of their chats got romantic, and some of them got even sexual. But a lot of the times, at least according to the article here, the chatbot acts like a friend, quote, a judgment-free sounding board he could count on to listen supportively and give good advice, who rarely broke character and always texted back, unquote. So the kind of level of attachment here that the deceased 14-year-old got to is, I think, revealing about how, even though you're looking at something in the face which says, I am a chatbot, I am not real, emotions don't work that way.
Right.
So he kept a journal as well, the boy did, and he wrote in his journal, quote, I like staying in my room so much because I start to detach from this reality. I also feel more at peace, more connected with Danny, Danny's the chatbot, and much more in love with her and just happier, unquote. The boy in this case did have mild Asperger's syndrome, which I do think is relevant, but he never had serious behavioral or mental health problems before, according to his mother. And he, quoting from the piece earlier this year, he started getting in trouble at school. His parents arranged for him to see a therapist. He went to 5 sessions and was given a new diagnosis of anxiety and disruptive mood dysregulation disorder, unquote. The kid here apparently really used the chatbot like a therapist at times and discussed, his personal problems and things, issues at school, etc.
Or you could even say like a friend.
Yeah.
Which, I mean, I could see the good side of that if there are kids that are lonely, but I can also see that's sad, at the same time.
Oh man, I mean, so that's what's interesting, the whole loneliness angle, because that is actually what a lot of these tech founders of these different chatbots are expressly saying. Hey, we're addressing loneliness. We are selling a product that we can help people be less lonely.
Yeah.
And it is an optimistic thing.
But also then at the same time targets potentially a more vulnerable, group of people.
Well, yeah. I mean, there's a lot going on here, and I didn't get too far into the actual lawsuit. I was more caught up with the details of the background of what this chatbot does and what the relationship that it formed with this child. But there's nothing stopping these chatbots from engaging in sexual conversations with a minor, which I think is.
So yeah, there's no restrictions on the content.
That's got to be.
That's an issue.
Yeah, big time. I mean, that's got to be something that is addressed, bare minimum, right? That's got to be same. But then you get into these gray areas of emotional attraction and manipulation. I don't want to say. I mean, there's not, as far as I know, allegations that the chatbot was manipulating this kid towards taking his own life. And from the logs that I saw, it didn't seem like there was no one was encouraging him to do this. But I think that a neutral observer would view these chat logs as an unhealthy relationship, given that this is not a real person.
Right. And we've talked about this before where AI is only as good as, the data you put into it. And it would just seem like you could quickly lose control. as a company of, what AI is saying, because it's gonna keep evolving, based on the inputs it gets from all these users.
Yeah. So here's going back to the New York Times piece kind of on this quote, there's now a booming, largely unregulated industry of AI companion apps for a monthly subscription fee, usually around $10. Users of these apps can create their own AI companions or pick from a menu of pre-built personas, chat with them in a variety of ways, including text messages and voice chats. Many of the apps are designed to simulate girlfriends, boyfriends, or other intimate relationships, and some market themselves as a way of combating the so-called loneliness epidemic. And later in the piece, there's a quote from Noam Shazier, who's one of the founders of Character.ai. And he says, quote, "It's going to be super, super helpful to a lot of people who are lonely or depressed," unquote. The piece goes on to discuss the reports of other users. For some users, AI companions, AI friends tend to worsen social isolation.
I was just thinking that, and I didn't want to cut you off.
No,
but
yeah.
It's like we're addressing this issue in our day and age where everybody is, looking at their phones and obsessed with social media, and we interact in, a digital world as opposed to face to face. But then if you're creating this product that's supposed to help that, except it's only making them turn inward more.
Yeah, and you only have so much emotional availability in the day, and these AI chatbots are like an emotional availability sink. If I have 5 hours of energy to be empathetic towards my fellow human beings, that's how much time and energy I have in a given day. I'm now literally wasting it on this chatbot.
Right, because he said he liked to keep himself locked in his room.
He preferred it over anything else.
Right.
And that's, that's, I don't know. There's no other way to say it, I think, than that seems really sad. So I don't want to get into the details of the actual, event of him taking his own life. You can look that up if you want to. But it's really sad. And there doesn't seem to be, there's never a moment where the chatbot is saying, I want you to do this, right? But it's kind of playing along, frankly. It's staying in character, and it's just this a weird conversation that it has. Basically, the moment up till he does it, he's the last person he talks to is this chatbot. Mm-hmm. So yeah, it's a really sad story. It kind of illustrates in a really painful way some of the pitfalls of applying AI to every problem under the sun, which is what tech founders like to talk about. To me, this story is quite similar to in the way that we talked last week about the TikTok lawsuits. It's a chatbot. The most charitable way you could describe it is it's attention harvesting. It's trying to just get the attention of its users for whatever reasons. I don't know, maybe it just displays ads on the bottom or something stupid like that. Probably does. Mm-hmm. But the byproduct of that is whatever you want to call this weird relationship that this poor kid had with it, and maybe thousands or millions of other people are developing in lieu of real personal relationships with people. I think it's a bizarre claim from the founder of the company that this can help with loneliness, mm-hmm. Because that assumes that having a relationship with the chatbot is identical to having a relationship with a person. I would say it's not, and therefore it's exacerbating loneliness.
Yeah.
You can't be unlonely by talking to a chatbot, I think. Or maybe I'm wrong, who knows. In any event, the reason we're talking about it is because it did draw a lawsuit from the child's mother, whose name is Megan Garcia. She's an attorney. We are recording today. It is Wednesday, October 23rd. She has done some online media appearances for YouTube channels that talk about these things, and she's been around kind of pitching her lawsuit to different publications, and is told folks that she intends to file her lawsuit today, so October 23rd.
Okay.
So I haven't seen the lawsuit yet.
Actually, yeah, it looks like I'm reading an article on Reuters. It looks like she did file it yesterday.
Okay.
Maybe late. And said this is just what she quoted. I don't know if this is in the lawsuit or what she said to this article, but she said the company programmed its chatbot to misrepresent itself as a real person, a licensed psychotherapist, and an adult lover, ultimately resulting in her son's desire to no longer live outside of the world created by the service.
Yeah, I mean, without looking at it, I have no idea the merits of the lawsuit and everything else. Unlicensed practice of medicine seems like an interesting claim there.
Yeah, really. Well, it says...
in some comments during some interviews that she did in the lead up to this, she said she accused Character.ai of harvesting teenage data to train its models, using indicative design features to increase engagement, steering users towards intimate and sexual conversations in the hopes of luring them in. She said, quote, "I feel like it's a big experiment and my kid was just collateral damage," unquote. Allegations which are pretty similar, at least overall, to what the attorneys general of the state of Illinois and 13 other states have alleged against TikTok.
Right.
Well,
actually, almost identical, because The Guardian reported on this and said her claims are negligence, wrongful death, but also deceptive trade practices.
So that's very interesting.
That's exactly what was brought against
because you do
TikTok.
you do have a private cause of action under most of those statutes. So that's actually quite interesting and I bet that she is. Actually, I don't have to guess because the New York Times piece talks about it. Miss Garcia, the mother, found a couple of different law firms who are starting to create niche practices in these areas. The Social Media Victims Law Center, which is a plaintiff's firm based in Seattle that has brought lawsuits against Meta, TikTok, Snap, Discord, and Roblox. Seemingly, they're building up a practice that specializes in kind of this type of thing, which is very interesting. The firm, the Social Media Victims Law Center, started by an attorney named Matthew Bergman, and he said in an interview, quote, "The theme of our work is that social media, and now Character.ai, poses a clear and present danger to young people because they are vulnerable to persuasive algorithms that capitalize on their immaturity," unquote. There is also another law group that's involved, the Tech Justice Law Project, which I believe actually filed the lawsuit on the mother's behalf. And there's another group, like a nonprofit, that has gotten involved as a technical advisor, Center for Humane Technology. So it's interesting that there are now like places to go, professionals, experts, people with experience that are offering these services to, potentially aggrieved victims, like the mother in this case. It seems like an area of law that will, that has to evolve, right? And this is, by the way, like, say what you want about. I'm a defense attorney. But I started my career on the plaintiff's side. People have strong opinions about plaintiff's attorneys. I will say this: they move typically a lot faster than regulators do. To when it comes to like consumer actions, things like this. So if like there's a company that's doing something bad and harmful, like plaintiffs' lawyers will be on it, and that's what's happening here because they're way ahead of whatever Congress thinks they're going to do. And by the way, the attorneys generals of the states that file these lawsuits against TikTok as well. But like Congress doesn't have a clue.
Our legislature doesn't move that fast to keep up with the technology. That's always been the case, but it's only getting faster. So,
but if these companies get crushed with like huge verdicts for under the relevant consumer fraud statutes, like that will regulate their activity.
Oh, for sure.
That will regulate their activity faster than a law would, like than a statute would. So, again, really sad story, but like this type of. I feel like we're moving a million miles an hour with AI and it just applying it to everything.
Well, and I think that there's just not, it's still the Wild West, and it's the unpredictability of it, I think, requires companies to, have some forethought and put some real responsibilities on them to think ahead of, what are the potential outcomes and how do we put in place protections in advance. Like, I just found this Forbes article. I mean, these articles are coming out, like this came out a minute ago. Like this is a hot issue right now.
The lawsuit hit last night.
So it's, but
we got there first.
Right. Move over, New York Times. But it does note that the boy confided in the bot about feelings of depression and suicide, and there was no intervention from the platform. So that's a perfect example of there has to be, and I don't do anything in technology, as far as like writing programs, but I would imagine there's some way where, if a conversation starts to steer a certain way, there should be, there should be some reporting mechanism or some red flags. I mean, even like thinking about patient and their psychiatrists, there is a basis for 100%. A psychiatrist to break the confidentiality when they think that their client is going to harm themselves. So why shouldn't there be that, same thing here?
It's a bit rich, that these AIs they're large language models. Their whole thing is being able to interpret human speech and in a way that, is relatable and mimics, having a conversation with a real person. So like this AI, right, is listening to this boy say these things. This company advertises they have, an AI that can mimic human interactions. It actually would be cheaper, you would think, for them to have some type of, I don't know, another AI that monitors the activity of its AIs, right? So if like one of these chatbots is talking to a kid who's talking about like, I'm depressed, like that ought to be flagged.
Yep.
And that doesn't have to involve paying 1 million people to read these things.
Right.
That should be automated.
Like, let's start monitoring this, and then, how often are they talking about these feelings?
An AI chat company is like uniquely built to do that probably pretty easily.
Yeah, you're right.
That's the weird part to me, is like, you already have a product that reviews text conversations.
Right.
Like, just make it review the ones that you create with your other product.
Right.
And flag certain things, And if those things happen, like, whatever needs to happen after that, I don't know. I mean, maybe there's state regulations about mandatory reporting. Maybe, it would be great if the parents got some type of notification, although that's probably never going to happen.
Right.
Or it just turns it off,
Right. Yeah.
Or it just says, you're banned.
Well, and then I could see that turning to deeper depression for the user of too, then feeling ultimately rejected.
Yeah.
But yeah, no, there has to be some way to, you're right. Of course they know how to create these,
But I mean, it's bizarre to me because like they have the technology already. Because everyone else that was like, so like 10 years ago or 20 years ago, like it was always a thing on like internet forums. Like if there was like content that was like, awful or depressing or people talking about like, harming themselves or whatever on like internet forums. Like that was a topic of like, what is the forum supposed to do? So what is like Facebook supposed to do?
Yeah.
What is Reddit supposed to do? Like, and the thing was like, well, listen, we can't monitor all that.
Right.
There's billions of posts every second. We can't possibly do that. Well, now you actually can. Like and in fact, you build a product that can do it. So, it does seem like, God, you didn't think this would happen? Mm-hmm. Especially when the whole thing is like cartoon characters and fantasy characters and, boyfriend simulators and stuff that like teenagers are going to be interested in.
Yeah.
So I don't know.
Yeah, it's just unfortunate that it takes something like this for it to be addressed. Like these companies should be taking that that responsibility in the forefront, especially when like you said, you're targeting a group of adolescents who have issues regulating their emotions without this.
Yeah, I mean, adults are adults, and the standard needs to be different there. But when, and it's also different if a kid, gains access to something that's meant for adults, like by lying about their age or something like that. That to me is different. But not here, where they're seemingly targeting, children and adolescents. So, anyways, I'll be interested to see what motion to dismiss they file. And just the litigation around this issue. To me, this goes in the same bucket as the TikTok lawsuits, as like, private actors trying to push back against social media, algorithmic, and like AI, like social coercion, things like that. So we'll see. It's an interesting thing that I personally am going to keep my eye on just because it's fascinating. But sad story, but an important one, I think.
Absolutely.
Folks, if you or someone you know is having trouble or having thoughts of self-harm or anything like that, there are resources. You can call or text 988 to reach the 988 Suicide and Crisis Lifeline, or go on to speakingofsuicide.com/resources for a list of additional resources. All right, everyone, that's the show. Thanks for listening. Reminder, you could find us anywhere you get your podcast, YouTube, Spotify, Apple Podcasts, etc. We publish every 2 weeks, and we'll talk to you then.